Case law update. This was I was reading, obviously I read a lot of highbrow material on my way to work. I don't just read the Metro, but I was reading the Metro, and Michelle Dewberry was in there, and you would have seen this, and it was quite relevant to the first set of cases I'm going to talk about. I'm not going to say what line of the debate I fall on, but Michelle dressed up as a cat on GB News to highlight the recent space of some children identifying as animals at school. And she was criticised for this post because she felt that she was making fun of a young child at school who'd identified as a cat. And her basic position was how ridiculous for children to do that, and you can't identify as a cat. And it's blown up into this big debate on Twitter. And there's various differing views, most of which I read in the Metro. So I'm going to talk about expressing beliefs at work because, on a more serious note, there have been a number of cases over the last year or so on this, and it's really the question is, how far can employees go at work saying what they think, what they believe, whether it's a religious or other similar belief? And can an employer control what an employee says at work or outside of work in social media? Let's say three main cases on this. Two of them are quite similar, and that's a case called Forstater and a case called Higgs. Higgs was actually decided last week, so it's quite recent. Forstater and Higgs were both social media cases. So in Forstater, it was a consultant who tweeted her gender-critical beliefs. So her belief, which was the same as Higgs, which is this common belief that your sex is a biological fact. You can't choose your sex. You can't choose your gender. It's a biological fact. And that was something that in Forstater and Higgs, that was their belief. Forstater tweeted about this a lot, was quite a high-profile figure on this view. Wasn't really related to her job at where she worked, but in social media, she was quite a frequent poster of this view. And colleagues at work took offence to this, or some of them did, and complained. Similarly, in Higgs, Higgs was not a teacher, but she worked in a school. She was pastoral care administrator. And on Facebook, she reposted a post setting out similar beliefs, gender-critical beliefs. And some parents complained and said, well, we don't think this person should be expressing those views if they're working in a school. And the outcome of both is both got sacked for posting their views online, for a combination of things such as bringing the employer into disrepute, or potentially bringing the employer into disrepute, and generally upsetting colleagues or parents in the Higgs case. And they brought claims under the religion and belief discrimination law, and they both won. And the first question was really, well, if this is an offensive belief, which some people believe it is, some people don't, surely it can't be protected under the law. And that's been answered quite clearly with a yes, it can, because that's what freedom of speech and freedom of belief is all about. There will come a line when there'll be something that is so offensive that it's not worthy of respect in a democratic society, which is the test, but it's a fairly low bar. And so offensive beliefs are generally going to be protected. So does that mean then employers just can't do anything about manifesting those beliefs? And that's where an employer can sometimes do that, if the manifestation of the belief becomes inappropriate. And it's that these cases are struggling with. And in Forstater and Higgs, they said what those employees had done was not inappropriate as far as the court could see. It was not an unreasonable way of manifesting their belief, and they should be entitled to do that. And dismissal was going too far. It was a disproportionate response to that expression of belief. If you contrast that to Makareth, which is another case on there, and what was important, I think, in Forstater and Higgs is both of those employees were saying, I'm happy, to toe the line at work. I'm happy not to express these views when I'm at work. This is my social media presence. It's nothing to do with my job. In Makareth, Dr. Makareth was a disability benefits assessor for the Department of Work and pensions and held very strong Christian beliefs. Again, similarly to Forstater and Higgs, that gender and sex is immutable and is a biological fact, and you cannot choose to change it. And the difference with him was that he said, therefore, when he was assessing customers and service users, he would not use chosen pronouns of someone who was identifying as a different gender to their biological birth, sex, gender. He said, I'm sorry, I just can't do that. It's against my Christian beliefs to do that. Can you not make it so I don't have to assess transgender individuals, etc.? And the DWP tried to accommodate this, but they essentially said, we can't do that. You're going to have to do this, and he wouldn't do it. So they dismissed him. And in that case, he lost his claim, because in that case, the court said, well, that is an inappropriate manifestation of your views, because it's going beyond anything, and the response was proportionate because you couldn't do your job because of your manifestation. But I think it just shows that it's a difficult one. So I think the lesson for employers is that people who have beliefs, and possibly extreme and in some people's views offensive beliefs, are not only allowed to hold those beliefs, but they are allowed to manifest them, until it gets to a point where it's an inappropriate manifestation of that belief. And there will come a point when I think an employer can say and step in and try and put some rules around what they can and can't do, as they did in Macareth. But I think having a blanket rule, for example, saying no employees are allowed to manifest their beliefs at work, which I think some employers have considered doing. I think given the latest cases, that's going to be difficult to have a blanket rule like that, because that will be probably a disproportionate response. Yeah. Yeah.
You said that they also were bringing companies.
Yeah.
So what was how was that challenge?
Because they said, well, in Forstater they said it didn't really. They said it was a fairly measured. I mean, it's quite well known. If you can look online, you can see them. They said it was a fairly measured way of expressing the belief that is generally, it wasn't inappropriate. And so they said it didn't bring the company in disrepute. It wasn't really related to the company she worked for. It was an American think tank company. It didn't really relate to their business. And I think it's because they said, well, it didn't bring you into disrepute, and we don't think any reasonable person would have thought it did. I think the school one's a bit more interesting when you've got, they weren't a teacher, but she was complaining about a government consultation about how sex education is taught in schools and how it's anti-Christian and it's, and the gender critical aspect of it was wrong. So you can see that was a bit more related, and that was the school's view was, we think parents will take that to mean you are a transphobic, homophobic person. And that was and Higgs has actually gone back to the tribunal to decide. She's won her appeal, but it's gone back to the tribunal. So she may or may not ultimately win on discrimination. But they said that you jumped to a conclusion that that's not her belief. She's not transphobic, not homophobic. You've got to look at what she posted and decide. Exactly, they made the wrong assumption. So that may still go the other way, that one. But that's why it's so difficult, I think, to know whether your response is proportionate or not. But that's a line of, and they will carry on, I think, those cases. I think we'll see more and more. As you know, employees over the last few years have been encouraged to speak up. And we have a lot of diversity training and people were speaking their mind. I think this is an increasing risk that people have views that some people find unacceptable. Moving on, so I've got one other thing, which are shorter. The next case I want to talk about, this is quite a discrete point, but it's a common thing we see, and this case went to the Court of Appeal, so it's worth mentioning. And it's where employers, I'm sure none of you have ever done this, where you overpromise something in an offer letter, and you think you've referred to some rules somewhere that give you loads of discretion. And its question is, does that discretion actually limit what you've promised the employee? So here it was a PHI policy, and this happens a lot with PHI policies. And in the offer letter, what was unusual here is the offer letter actually described the level of benefit. So it said, we will pay you 75% of your salary, provided you meet blah, 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 and it just set it out. It didn't say we will provide you with PHI insurance. It said, this is what we will give you. This is the benefit we will give you. And then there was a line that said, this is governed by an insurance policy, essentially. And what was in this promise was a 5% escalator. So it said every year it will go up by 5%. And they relied on insurance. They had an insurance policy to provide this benefit. They also had a company handbook which said, oh, but we can change our PHI benefit whenever we want and the level of benefit. It was in dispute whether or not the employee ever saw that employee handbook at the time they were hired, but they did see the offer letter. And sure enough, after a few years, and the employee ended up going on to PHI, and after a few years, they changed their PHI provider and there was no escalator in the new policy. And the employee stopped receiving this 5% increase. And they said, why am I not receiving my 5% increase? And the employer said, well, because we've changed our PHI policy. They brought a claim, breach of contract, and they won. And the court said, your contractual promise was to provide 75% of salary with a 5% uplift every year. If you want to fetter that with some discretion, you have to put it in the document where your promise is, if you're going to describe it that way. You can't put it in another document that is referred to somewhere else unless it's very, very clear and brought to the employee's attention how that contractual promise could be amended. And so I think it's unusual to do that. I mean, you don't ordinarily see employers actually spelling out an insured benefit, but I always get nervous when you see contracts saying we will provide life assurance with 4 times cover. Are you always going to be able to provide that? And PHI certainly, when you start talking about 66% of salary or 75% of salary. And if you do that, you need some wording that says, provided that we may amend the level of this benefit from time to time at our absolute discretion. I think if they'd had that in the offer letter, they might have been okay, but saying subject to the rules of the policy from time to time, which is somewhere else that you're never going to see, won't do it. So I think that's the lesson. It's nothing new. We've always known this, but it's a risk sometimes. The temptation sometimes, particularly in offer letters, when you're trying to entice the person to sign their contract with all the caveats in it, is to promise lots of things and just talk about the positives. And that's why I hate offer letters. I just don't like offer letters. I just like a contract that has all the caveats and all the lawyer stuff in it. And just an offer letter that just says this is subject to, taking up references and immigration checks. So it's just a reminder, this one. It's nothing new, but just a cautionary tale. So I'm sure no one in this room has ever had that problem. And the last case I'm going to talk about is on privilege and internal grievances. This is another one that when you first look at it, you think, this is a bit surprising. It's called Chakraborty. So it's a grievance at Dundee University. A university professor was appointed to investigate the grievance, which they did, and they produced a report. And they were a sort of quasi-independent investigator, produced the report, provided it to the legal team at the university. The legal team sent it to their external lawyers for advice on what to do next. And in addition to advising, they also amended it. They amended the report, and they said, well, we think, no, when you say this, you mean this. And they changed various bits, sent it back, legal team sent it to the investigator, and the investigator agreed with the amendments. So the final report was the amended version, which went to the employee. Helpfully, they put a footnote saying this report has been amended following legal advice. Funnily enough, the employee saw that and thought, I'd quite like to see the original version of this report. And so they applied for disclosure. The university said, oh, no, that's privileged, because, went to our lawyers for advice. And of course, said, no, it wasn't. It was a report that was finished by the university professor. The fact you then took legal advice on a finished, signed-off report does not mean that wasn't a draft. That was a document that was done for the purposes of a grievance, not done for the purposes of taking legal advice. So then they said, well, if that doesn't work, we think it retrospectively has become privileged, because the employee will be able to tell what the legal advice was if they see the original report, because they'll be able to compare the two documents. And they said, no, that doesn't work either. And by the way, by footnoting the fact you've taken legal advice, you've waived privilege in those amendments anyway. So that didn't work either. So I think the lesson here is, if you do want to produce drafts of decision letters, reports, anything on an internal, and send it to your internal legal team or external lawyers before you produce it, and you want to keep privilege in that, keep it as a draft, that has been prepared for the purposes of taking legal advice. It's still going to be, it's still a chance that someone will say, well, no, the dominant purpose of that document is not for taking legal advice, it's for the grievance. But I think provided you keep it in a draft for that purpose, we do that all the time with you guys. We look at drafts of things that you produce, and you should be able to do that on a privileged basis. But certainly if you then produce it and put a footnote saying, we've taken some legal advice and we've amended this document, then you're going to have to give disclosure of that legal advice. So don't do that. Don't do footnotes like that. So yeah, another just a cautionary tale on that one, just drafts for the purposes of taking legal advice until it's been signed off. That's me. Too bad on time. I'm going to hand over now to Catherine.
Okay, so I'm going to kick off with the legislation update, and I'm going to start by talking to you about 3 new pieces of legislation that are making their way through the legislative process at the moment. Although perhaps they won't feel that new to many of you, it's certainly some of these we've been talking about for a very long time now, but they are inching closer to becoming law and being implemented. So we thought it was worth mentioning them here today. So between them, these 3 new acts that I'm going to start with are aimed at improving the protection of pregnant mothers and new parents against being made redundant, introducing a new concept of neonatal care leave and pay, and introducing a new concept of carers leave. And so all 3 acts are essentially there to create a framework for these 3 new rights, but leave the finer details to be fleshed out in regulations. Now, we haven't yet seen those regulations, so they've not yet been published. So there are a couple of areas where we don't have complete clarity about how all of this is going to work. But we have enough information to know what's coming our way. So I wanted to start by talking about redundancy and the enhanced redundancy rights that are coming in. So the legislation that we're talking about is Protection from Redundancy, Pregnancy and Family Leave Act. And that will extend the current protection against being made redundant. It currently only applies if you are on maternity leave, adoption leave or shared parental leave. So under the new regime, that will be extended to mothers from the point at which they notify their employer that they're pregnant. And again, for an extended period that is to be set for when people return from leave, whether that be maternity leave, parental leave, or shared parental leave. So the regulations itself are going to set out what that period will be, but our current understanding is that it will be 18 months from the period that the leave starts. Again, whether it's any of those 3 leaves. So in terms of timing on this one, the government has said that the regulations will be laid before Parliament in due course. So we don't really know what that means when time allows. There's no certainty, but it's thought that these new rights are likely to come in April 24. The next one I wanted to mention is the neonatal care leave and pay. And so this one is the very originally named Neonatal Care Leave and Pay Act. But there's a considerable amount of detail here that's still to be fleshed out in the regulations. So we'll wait to see what those say. But the overall intention with this one is that a parent whose child is admitted to neonatal care will have a new statutory right to take leave in those circumstances. Now, full eligibility requirements, again, are not yet known and, again, will be set out in the regulations. But we're expecting that in order to be eligible for this leave, the baby will need to have been in neonatal care within 28 days of birth. They'll need to have been in that care for at least 7 continuous days or longer. And the maximum period of leave that we think is going to come in under this new right is 12 weeks. And that leave will need to be taken within 68 weeks of birth. It can be taken in blocks of 1 week, or it can be taken in multiple blocks. And the idea really is that it will be combined with the other forms of leave that are available. So new parents will be able to take up to 12 weeks of this new neonatal care leave, in addition to the other statutory leave entitlements. So this right would be in addition to the 52 weeks maternity leave, or in addition to your 2 weeks paternity leave. This right will apply from day one. It's a day one right. But in addition, if you've got that magic 26 weeks continuous service, then that will entitle you also to some pay. That's subject, of course, to certain eligibility conditions, but it's thought that that pay will be calculated based on the statutory rate, sort of the lower rate, rather than any enhanced rate. So it won't be like the rate that you get for the first 6 weeks of maternity leave, for example. It will be the set statutory rate. Think about the timing of this one. Slightly more complex, I think, this one to implement. The government has said that there will be 7 statutory instruments that are required to implement this legislation. So it's going to take some time to work through the legislative process. So I think that one we're probably not looking at until April 2025, so not next year, the year after. Carers Leave then is the next one. So Carers Leave Act is the legislation, and that creates a new day one right to unpaid leave to provide or arrange care for a dependent who has a long-term care need. Now that leave can be taken in half-day or full-day blocks, totaling up to 1 week in total for each year of employment. And for this one, dependent will have a very broad definition, and essentially is likely to extend to anybody who the employee provides care for on a long-term basis. So it's not contained to family members, for example, or children. It's wider than that. So anyone who you provide care for on a long-term basis. So this leave will be different to other kinds of leave, like dependence leave, which is, as I'm sure you all know, is designed really for emergencies, and parental leave, which obviously is aimed at children dependents. I think the objective really with this one is to add some additional flexibility for those employees who are carers, mainly of adult dependents. Timing on this one, as with the other earlier acts, regulations are again required. We'll get those in due course, but this one is likely to be April 24, so a bit earlier than the neonatal care. Sticking then with the family-friendly theme, I wanted to give a mention to the Flexible Working Bill. And again, this is in particular one that we've been talking about for quite some time, but it has come one step closer in May to becoming law. So as I'm sure most of you know, the headline change on that one is making the right to request flexible working a day one right. So doing away with that current 26-week qualifying service period. Other notable measures on this one include a requirement for employers to consult with the employee where they're going to decline the request for flexible working, allowing employees to make 2 flexible working requests in a 12-month period. Currently, it's only 1. And reducing the time limit that employers have to respond to flexible working requests. I think 3 months at the moment, and that will be reduced down to 2. And lastly, removing the requirement on the employee, the burden on that employee to detail what effect they think their flexible working request will have on the business, and offering ways on which the business might be able to deal with it. So that will go. But what won't change is the 8 statutory reasons on which that you can refuse a flexible working request. So those will still remain. So that bill is at its 3rd reading stage, so it's nearly there. And it's possible that it could become law this year, but I think it's much more likely that we'll be looking next year. Yes.
You said the 8 things name, are they going to be exactly the same?
Yes, there's no plans to change those. Yeah, and there was some consultation on whether those should be amended or done away with, but that's not something that's being taken forward.
Just one on the parental leave, and I was not there, but remind me, it was not a legal parent of another children, but you are after maybe.
That's a good question. I'd have to check actually what the eligibility requirements are. I don't know if any of your panel can know that off the top of your head.
Do you mean on parental leave? Do you mean new carers leave?
Yeah.
Yeah, it's not, I think it's quite.
Oh, the new carers leave. Sorry. Yeah. No, parental leave. Yeah. I don't know about parental leave. I think there are certainly set eligibility requirements. I think it's primary responsibility for the child. Yeah, but I need to double check the legislation, but I can do that and come back to you on that. Okay, so there was one other last bit of legislation that I wanted to mention, and this relates to harassment. So there's a new bill, Worker Protection Amendment of Quality Act 2010 bill, snappily titled. But what does this one do? Twofold. It will introduce a new proactive duty on employers to take reasonable steps to prevent sexual harassment in the workplace. And secondly, it will also reintroduce employer liability for harassment of staff by third parties, so clients and customers. Some of you may remember that around 10 years ago, the law that made employers liable for harassment by third parties was repealed by David Cameron's government. And this bill looks to reintroduce that. And those protections actually go a little bit further again. So under this new bill, employers will have a defence to claim of third party harassment if they can show that they took all reasonably practical steps to prevent it. And this is not just limited to sexual harassment, that second point. It covers all types of harassment based on the relevant characteristics. So again, the timing on this one is also 2024 at the earliest. But there are a couple of things I think employers could start to think about now. I think training, in particular, in light of the defence, is likely to become even more key than it is now, not only for managers, but also general staff and workplace more widely, perhaps more so on how to handle unwelcome advances and interactions with third parties, and ensuring that staff feel that they can speak up and raise concerns without facing consequences. It's probably also a worth a review of your current policies, see if they can be improved in any way, and also taking a look at terms that you've got in place with suppliers. Do they require suppliers to comply with certain of your policies, maybe your equal opportunities policy or your respect in the workplace type policies? So it could be worth digging those out and taking a look. So that's it from me on the legislation roundup. So lots to look forward to in 2024 in particular. I'm going to pass over to Miriam, who's going to talk to you about some of the new guidance.
Hello everyone. I was quite pleased when we were planning this session, and I volunteered for updated guidance because actually not much had happened until last month, when there were a series of new initiatives and things announced by the government. So I've got lots more to talk about. So as indicated, I'm talking about guidance, and I'm going to kick off by looking at two recently issued pieces of guidance. The first is about dismissal and re-engagement, or fire and rehire. And the second one is about guidance issued by the Information Commissioner about data subject access requests. So quite different types of guidance. So looking at fire and rehire, I think if you came to this session last year, I was also talking about fire and rehire, or dismissal and re-engagement. It's been a hot topic in employment law for a while now, or even beyond employment law. My mum, who has no interest in employment law, has views on it after reading about what P&O did last year, where they sacked 700 individuals without a process. So it's a perennial hot topic. And I think what's clear from this year already is that the trend of it falling out of favour as a practice is continuing. Even before the pandemic and P&O ferries, employers are generally reluctant, I think, to take forward a dismissal and re-engagement process. But they did, some did. But I think now the trend is definitely moving away from that. And that's been helped in no small part by a series of government interventions in this area, including the newly issued proposed statutory code of practice in this area. So this was the one thing I was going to talk about, because it was introduced in January this year, and there was a consultation on it that ran until April. And in terms of the key points of this code of practice, what it says is that it doesn't prohibit fire and rehire or dismissal and re-engagement, but it really presents it as an option of last resort now. The code also makes clear that it's focused on contractual change programs. So where you are wanting to introduce a change to terms and conditions, it's not intended to cover things like redundancy processes. It's really about contractual change programs, and it applies. The code applies irrespective of the number of people that you have in your process. And I guess the final point to make about this code of practice when it comes in is that it really seeks to encourage employers to take reasonable steps to think about alternatives, not only to dismissal, but to the whole concept, I think, of dismissal and a re-engagement or fire and rehire. So when's it coming in? When parliamentary time allows. That's the continuing theme of my section. Everything's coming in when they can get around to it. But this probably will come in, I think, during the course of this year. So the second piece of guidance I wanted to mention is the ICO guidance on subject access requests. How many people in the room have to deal with subject access requests? Let's have a show of hands. Sadly, me too. Yeah, a few of you. So this guidance was issued by the ICO at the end of last month. And really the context to it is that the ICO said in the last 12 months, they've had about 15,000 complaints from employees and about subject access requests. And the quote from the Information Commissioner, if I can't read it without my glasses, is that they think many employers are misunderstanding the nature of subject access requests, or underestimating the importance of responding to requests. I'm sure no one in the room falls into that category, but they felt it was time to give some more guidance about subject access requests. And for those of you who do deal with DSARs in this area, I don't think the guidance will tell you that much that you don't already know. It's a helpful reminder of some of the key issues, but there are some nuggets in there, I think, that are worth drawing out. The one that I found most interesting was about witness statements or interviews taken in the context of an internal process. You'll often find that data subjects, if they're involved in a formal process, will ask for, interview notes or witness statements of a disciplinary or grievance that they've been involved in. And that's quite difficult for you as employers to deal with, because obviously those statements and interview notes will contain the data subject's personal data. And there's often a balancing act about how you manage that. Do you redact it very heavily, or what do you do? And what the Information Commissioner says here, I think quite helpfully, is that where there's where the person being interviewed has been given an expectation of confidentiality, and you can't protect that confidentiality through redaction, you can consider withholding it. I think that is helpful guidance from the ICO. It's what lots of people I think were doing in practice anyway, but it's helpful to have, I think, that written down, because it's obviously an often contentious area when dealing with subject access requests. Of course, there's always a bit of a tension between privacy rights and employment rights, and walking into internal process meeting and say, don't worry, it's all confidential, we'll never reveal your identity to anyone, may help you on a subject access request, because you won't be able to just have to disclose it. But obviously a promise of anonymity forever does bring some problems for your process from an employment law perspective, and if the matter ever proceeded to litigation. So I think the guidance on this is helpful for subject access requests, but obviously you'll need to bear in mind these documents might end up being disclosed through another process, usually through the tribunal. It does also cover other aspects that employers grapple with about, for example, manifestly unreasonable, unfounded or excessive requests, and also deploying the management planning exemption, which is another one that's quite contentious. But I think worth a read if you're dealing with SARS. It might just help cement your views on what you're already doing. And I think there's some helpful guidance on some of the more contentious issues, such as witness statements. So yeah, when do you use management planning? And the only examples the ICO has ever really given about management planning, including in this guidance actually, are about redundancy programs. If disclosing something would reveal that they were potentially on a list of at-risk people. I think one of the criticisms of this code is there anything else that we might be able to use management planning for? But it's where disclosure would impact the business operations or reveal something to the individual. Has anyone relied on it before? Management planning? Yes, very good. Okay. Well, I'll read the guidance. I'm sure it will make you feel better. So, moving on to another headline-grabbing government announcement, this time around non-competes. So, this was announced on the 10th of May. I told you they were very busy in May. The government announced its proposals in respect of non-competes. Oh, have I gone on a slide? I might have to hand this to someone else to operate. There we go. I don't want no spoilers. So on the 10th of May, the government announced their proposals around non-compete clauses, which was much anticipated, given they've been consulting and thinking about it for the last 2 years. So we're all interested to see what they're going to say, and I'm sure you'll have seen some of the kind of coverage around it. So I think there are 3 key points to draw out from this announcement. First, there are no plans to make employers pay for non-compete clauses. Those of you with European operations, there are some European jurisdictions where that is required, and it was being considered by the government, but they decided that actually that was too much of a cost for business, so they haven't gone forward with that one. The second point to note is there's no change to an employer's ability to unilaterally waive covenant non-competes. You might want to do that as part of a settlement, and you'll still be able to do that. But the most groundbreaking proposal here is the decision that non-competes will be subject to a statutory limit of 3 months. So that has grabbed lots of headlines. I don't think my mum knows about that one, I have to say, but in the employment law and HR world, at least it is, and business world, it has caused a bit of a stir. It's worth noting that this is about non-competes. There are no plans to legislate in relation to non-solicitation provisions, non-dealing provisions, notice period, garden leave, or confidentiality. And that's really important to bear in mind, because when this comes in, and that's a question mark, those provisions will become more important. So bear that in mind. And why is the government doing this? Seems a bit strange, I think. But what they're saying is, well, no, this gives employees flexibility. It it puts more people out there in the talent pool, and so they're hoping to kind of boost the economy by having a more fluid labour market. It's worth saying that the government has said that these reforms relate to contracts for employment and worker contracts. So it's not intended to, for example, cover yet LLP deeds or partnership agreements. I think there's an open question about how broadly or narrowly the concept of employment contracts will be defined with these new rules. For example, is a settlement agreement covered? Could you get around this by having a non-compete in a settlement agreement? What about LTIPs on share plans? Are they employment contracts? Or will you be able to work your way around this by having longer non-competes in those types of agreements for... Say that again? Yeah, exactly. Well, all of this is to be TBC by the government. How are they going to deal with it? So there are potential ways that still may be open to employers for, you know, your most senior and sensitive hires. You may want to consider some of those loopholes if they remain open once things are a bit clearer. There's another open question. What if you've got non-compete provisions which are already longer than 3 months, as I'm sure most of you do? It's not quite clear what the plan is. Will they be completely void, or will they be enforceable up to 3 months and not beyond? I think current thinking is that they will be enforceable up to the 3-month period. Otherwise, the alternative would be for everyone to renegotiate their covenants. Of course, the normal principles behind restrictive covenants apply. You still have to meet the other requirements for a covenant to be enforceable. So in terms of timing, this is another one that will be introduced when parliamentary time allows. Who knows what that means? What should you be doing now? Well, obviously keep an eye on this. This will be a big change. I think you can still have non-competes. You can still have them at the moment for longer than 3 months, but start thinking about other ways that you might protect the business, your newest hires, your most sensitive appointments. Are your garden leave provisions okay? What about notice periods? Do you need longer notice periods if this comes in? And what about non-competes in other types of agreements? Is this the time to review those and make sure they're operating properly? So I think, sorry.
How often are they enforced?
How long are non-competes enforced?
Yeah, like if someone goes to the council for 6 months, it's something that's not, and then goes to the council.
How often? Well, no, there's always a lot of work for lawyers around non-competes because there are lots of drafting issues and so on. And, you know, although not all cases get to court, and there's often, a flurry of correspondence and so on until the parties decide they're going to get to a resolution. I mean, I think most disputes end up in some sort of agreement, whether it's to abide by the covenant or a different form of it. So you're right, they're hotly contested. And I think the real risk here for businesses is 3 months really going to be long enough for your most senior hires? I'm not sure that it is. So, don't want to cut you short, Frisia, so I'll speed on to Brexit. Sorry, had to mention it. So last month, obviously, the government decided that it would help me in my talk by making a further announcement. And I think this is an interesting one. So they published last month a consultation paper on proposed changes to certain areas of employment law in relation to the EU revocation bill. And so what they've said they'll look at is working time, record keeping, annual leave, holiday pay, and TUPE consultation requirements. But they also said that the vast majority of EU-derived employment law will remain, at least for the moment, unchanged. So this bonfire of employment rights that we've been reading about for the last couple of years is not on the cards at the moment. So briefly, what are they consulting about? I'll just give you a bit of a run through. So they're consulting about rolled up holiday pay. Some of you might remember that. We used to do rolled up holiday pay and then we didn't, and now it's back. They're also consulting about the two different types of holiday entitlement that employees have. You've got your Euro leave of 4 weeks, and then you've got your UK leave of 1.6 weeks. And you'll know that in different scenarios, there's slightly different treatment depending on whether you're in your Euro leave or your UK leave, particularly around sick leave and holiday. The plan is to just consolidate that 5.6 weeks. There'll be no Euro leave, so to speak. And the TUPE one is worth mentioning. There's been lots of discussion about what's going to happen to TUPE after Brexit. What they said for now is they're going to consult about a particular issue in relation to TUPE consultation, and that is, I'm not sure if anyone here has ever deployed it, there is a micro business exemption for TUPE consultation. So if you've got fewer than 10 employees, you can consult directly with the affected employees in a TUPE transfer. You don't have to consult with elected representatives. The government has decided actually we want to expand this category so that employers make it a bit easier for employers and enable them to consult potentially directly with individuals who are impacted rather than going through the process of electing representatives. So the two scenarios they're consulting on are where the business in question has fewer than 50 employees. So effectively they're extending the micro business exemption in that scenario. And the other scenario they're looking at is where the impacted number of employees is fewer than 10, regardless of the size of the business. They're saying in that scenario, we should just allow businesses to consult directly with individuals rather than with employee representatives. So two interesting changes. Some employers were consulting directly and anyway in those scenarios. So it's a reflection, I think, of trying to make employment law in the UK a little bit more pragmatic, less red tape, so we've been promised. But it's worth mentioning again that what this consultation paper says is that all other key areas of EU employment law, so family-friendly rights, fixed-term, part-time workers, they're not going to touch those at the moment. Of course, the revocation bill does give the government the ability to do that. And certainly the supremacy of EU law will come to an end at the end of the year. But I think we were all worried as employment lawyers and lawyers and HR professionals here today about this. Everything's going to change on the 31st of December. I think this is the only sensible way forward, a recognition that actually to make change effective, we're just going to have to take our time and reflect on it and deal with the most important issues on a more considered basis. So I think a good development. On that note, Farrugia is going to talk to us about developments in immigration.
First thing I would like to talk to you about is recent trends in immigration. And some of you may have seen some rather splashy headlines last month about how net migration has hit a record high of 606,000. Net migration is calculated on the basis of immigrants into the UK minus immigrants, looking at people who are moving in either direction for a minimum of 1 year. On the face of it, that does seem like a huge increase with 24%. However, if we look at it more deeply, we'll see there are some instances that we need to consider. There have been a number of applications under humanitarian schemes, for example, people coming from Hong Kong or from Ukraine. We've also seen recently, as these figures on the slides show, each year there have been increases in the number of work visas being issued, or people who are working here, they decided to remain and they are now extending their immigration permission. In the last few years, we have seen two quite significant events. most recently the pandemic. When that, at the outset of that, global mobility really just came to a crashing halt. People stopped travelling, they couldn't travel. Anyone who had plans to move to the UK or was thinking about it, it all went on hold. Now, in the last year or two, we're seeing all of those people coming over increasingly in the last year or so. And then the other big event, obviously Brexit. When we were part of the EU nationals with free movement, they didn't need visas to come here, to move here, study or work. Now, since Brexit, they do need to have the appropriate visa if they want to move to the UK. That's seen an increase in applications for, as I say, work-related categories. In turn, that's had an impact on employers who traditionally have been able to only recruit EU nationals. They didn't need to get visas for these people. Now those employers who may never have had a sponsor license are finding that they actually have to apply for a sponsor license from the Home Office because they're finding they can only bring these people in under a work-related category such as skilled worker or a senior specialist worker. That's led to an increase in the number of sponsor license applications. We were at an event with the Home Office last month and they told us that they're quite surprised that the sponsor license applications in a week had gone up from 400 to over 1,000. Now have around 80,000 sponsoring employers in the UK. With all these figures, we are still seeing the government emphasising its overall desire to bring down net migration, and it's been looking at various ways of doing this. In fact, it's been saying, various governments have been saying they want to bring down net migration for over 13 years. They're still saying it. Last month, with immigration as well as employment, last month seemed to be quite busy. The Home Office made the announcement that they've been looking at the student immigration route. They said that they consider the student visa category is a back door into obtaining, moving to the UK, getting a job, and then being sponsored and staying here in the work category. So they want to cut back on that. They're trying to make the student category less attractive. What they're now going to do, these are changes that are coming in January 2024. Right now, a student, when they come over, they can bring their spouse and dependent children under the age of 18. From January 2024, a student is not going to be able to bring in their dependent family members unless they are studying on a research-based master's or PhD program. The other big change the government plans to make is that they've said that a student will no longer be able to switch in country from student to a skilled worker unless they have completed their course. This is going to have an effect on a number of employers who, we see this time and time again. They bring in students, they offer them a temporary job. They really like them. The student's great. They're at the end of the course or towards the end of the course, they think. And this employer makes them an offer and say, we want to hire you, we're going to keep you, you're wonderful. And that's great. It won't be so great in January 2024 if the student hasn't finished their course, because you might not think to check that. So that's just something to bear in mind. You might want to have a look at your recruitment program or your processes, make sure you're ready for these changes if you do typically hire students through the year. Interestingly, the government's also recently announced they have made some changes to the Youth Mobility Scheme for Australian and New Zealand nationals due to entering into new free trade agreements. Right now, individuals coming in under the Youth Mobility Scheme can only come in if they are aged between 18 to 30 and for a maximum period of 2 years. From, I believe it's the end of this month for New Zealand nationals and from next year for Australian nationals, the upper age limit is going to be increased from 30 to 35, and these people are going to be able to work here from from 2 years to 3 years, which is great. Employers actually really like, from my experience anyway, they do really like people who are coming over under Youth Mobility Scheme, because as an employer, you're not sponsoring them unless you want to keep them beyond the end of that 2 year or soon to be 3 year period. So this is going to bring in more people, which is, I find that quite an interesting sort of disconnect between the different departments of the home of the government. That again, it's very typical. It's been going on for a long time. It's nothing new. One department just won't talk to another. There is that disconnect. There are various changes being made within the Home Office itself. Quite excitingly, they have got some IT systems that look like they're going to work. Sorry, being sarcastic there. That is actually quite interesting. One thing they've been slow perhaps to roll out is the ability for their caseworkers to work from home. Right, they have two systems right now. One system requires all these caseworkers to be physically in a Home Office building, and another one where some of them are able to work from home. They're quite excited that they're going to have the web-based caseworking system rolled out more widely to allow more people to work from home, because that's something new, apparently. This should in turn bring down processing systems for applications. So, for example, right now, skilled worker out of country visa applications take around 3 weeks. They're hoping to bring it down to 1 week without paying a priority service fee, which is quite good. And another change they've made, yesterday at 9 AM, they changed sponsor license applications to add to it a section where you can now apply for priority service at the same time as you apply for a sponsor license, which might not sound very exciting. It's actually really exciting for those of us who make sponsor license applications on a regular basis. Before yesterday, 9 AM, after we submitted a sponsor license application, we would have to send an email timed to arrive in the Home Office inbox at 9 AM on the dot. And we would do that every single day, because they would only give priority service to the first 60 emails received. And I believe they got over 400 in the first 3 minutes. It was great. We'd be looking at time saying, right, it's 8:59 and 17 seconds. Should I send it now? Will it get through the firewalls? How long is it going to take? So that's actually a big thing. You know, compliance issues. The most popular one we're finding is the right to work check, people. It is absolutely imperative, of course, to have a clear process, one that everyone who is undertaking the check actually does understand what they need to do, and they know what evidence they need to retain on file. We've actually found that there have been so many changes in the last 2 years made by the Home Office that it's very important to check that your processes are up to date. But it feels like there have been changes, the Home Office has made changes to the right to work process. Perhaps every couple of months, it feels like we keep saying as a joke, we've written more blogs just on the changes to the right to work process in the last 2 years than any other topic in immigration, simply. One change that's quite important is that previously those people with biometric residence permits or BRPs, as an employer, you would simply see that person either in a video call or in person, look at their BRP, take a copy, that's fine. Now, someone who has a BRP, they have to go online, they get a share code, they give that to you as an employer, you go online, look at the details in front of you on the screen, compare the photo and the details to that individual on a video call or even in person, and then say, right, that's it, you've done your right to work check. Another change that came in last year is the Home Office has started to license third parties to be able to undertake the right to work check for employers, which on the surface, that's great. It takes off a huge admin burden for you. You don't have to keep figuring out what's the check that you have to do and who do you do it for, etc. The one slight problem we have is that the Home Office hasn't confirmed whether or not if down the line it turns out that this third party that the Home Office has licensed, if they've made an error, can you as an employer still rely on the fact that they've made the check as a defence to any compliance issue down the line? They have yet to say that's okay. We're waiting to hear on this, but it's still new. So we do say, please, if it's a really good idea to check your offer letters and your contracts to make sure that the burden, the onus of providing the correct right to work evidence is most firmly on the employee. And it's very clear that they cannot start work until they've provided this to you. Those who are sponsoring employers, you'll have a sponsor management system, the SMS. Last year, we've noticed the Home Office has started looking at this increasingly. They're looking at the details you put on there. They've been auditing, actually contacting people who are listing on your sponsor license as your level 1 or level 2 users. We had an instance where they've, a number of people we've heard have been contacted and asked, are you still a level 1 user for this employer? And hopefully they've said yes. If they've said no, the Home Office will contact the employer and say, please, you need to get this in order, update your SMS. So far, there's been no enforcement action. Interestingly, on one relatively new client, we did a housekeeping exercise immediately on their SMS, and it was quite interesting that they've used about 3 different law firms in the last 9 years. That's fine, but all of them still had access to the SMS, which is also a confidentiality issue. Suggested with key dates is very important, especially expiry dates for people's visas, and this does lead on to common immigration pitfalls. We find sometimes people will do the correct right to work check. They've done the copies, it's all there, it's all on file, everything's perfect. Then they might not diarise the expiry date, or they have diarised it and it's overlooked. The day after someone's visa expires, unfortunately, they no longer have the right to work for you. They no longer have any automatic right to remain in the UK. In those circumstances, a new immigration application must be submitted as soon as possible for that person. If they have travelled and re-entered as a visitor, they will need to leave again for us to be able to submit a new application for them on an out-of-country basis. Interestingly, we have found that if they haven't travelled at all, the Home Office actually does have discretion to overlook periods of overstaying, and our record, with a recent spate of this somehow, our record is about just over 4 months for somebody. But obviously for these cases, we do put in representations and a strong business case and basically beg for the Home Office to exercise discretion. But there is that option if someone isn't here as a visitor, if they haven't travelled, they may not need to leave the country. They won't be able to work, but at least they can stay. And if they have children, it's just one less hassle for them. Another thing we are seeing occasionally is that sometimes an employer, they'll go through their recruitment process, you get to the end, you find the perfect person, offer them the role, they accept, and then it turns out that the only way they can work for you is if you sponsor them, and the employer doesn't have a sponsor license. We can actually turn around a sponsor license application, prepare it quite quickly, but the documents is where it might take some time, which an employer needs to consider and factor in. There may only be 4 or 5 documents that an employer has to produce, but they're very specific. There's not much leeway on what the Home Office will accept. So sometimes we'll say, yes, these are the documents you need. The employer will tell us that's no problem. 3 or 4 weeks later, they still haven't managed to get the right documents. occasionally we also get calls that from someone here in the UK saying, I've just run into someone who's here as a visitor from overseas and they've been here working. It does happen because people will think, I don't need a visa to enter the UK. They've been told they're fine to visit for 6 months. Technically it might be true, but in practice, not really advisable. It does very much depend on what someone is doing over here, the frequency of their visits, and how long they're going to be here for. Because some things are fine for a business visit. Other times it does tip it over to that person requiring immigration permission. And at that point, we can prepare an application for them to work, but we won't be able to submit it until they're on a plane and they've left our airspace, because they do need to attend a biometric appointment overseas. And hopefully everything works out within 3 or 4 weeks and they can come back. But because of that issue of a lot of people think they don't need visas, they don't ask the question and they bypass your own internal controls. And we've just had that fairly recently, and it does happen. Right. Those, I say, are the more common pitfalls. There are many more. I could go on. I won't, because apparently there are drinks.